morning, Mr. Salas.
Good morning, Your Honor. May it please the Court, I'd like to first address a few of the questions that were asked. On the cases, Your Honor, I believe the quote in J.C. Penney referred to where Quill drew the line between due process nexus and Commerce Clause nexus, and that a state has to get both to tax you. And the old cases were due process cases, and it doesn't take much to have due process nexus, but it takes physical presence, we contend, to have Commerce Clause nexus. The question about federalism. I don't think, Your Honors, that the U.S. Supreme Court has retreated in the state tax world. They just take their time to get to something. Cert denied, we all know, means nothing. So far, there have been 12 states on this issue. 5 have ruled no taxation of any kind, any tax without physical presence. 7 have ruled that they can. We disagree with the 7. I think the other 38, including this Court, will get there, and then the U.S. Supreme Court will take it at some point. The federalism, for example, it was 16 years ago the United States Supreme Court decided one of these business, non-business cases in Allied Signal. They waited 16 years before they took our Meade case, but they took it. And on April 15th, they gave guidance to Illinois on how to go forward. So I think they're going forward. On changing times, North Dakota pushed hard in 1992 to say that Bellis Hess was history, that we now had computers and we had fax machines and we had 800 numbers and we had a virtual world. Well, the law is the law. And they said in 1992 what they said in 1967, no physical presence, no nexus. The trademark cases versus the other cases. First of all, there's nothing in our record showing attributional nexus at all, but I see no difference in principle. The principle is there's one Commerce Clause, and the Commerce Clause has twice been held. No physical presence, no nexus, and it should apply to all cases, whether it's a trademark company or whether it's any kind of company or a bank or a financial company.
Well, in this case, I take it your mark is being used here, used to sell products, and indeed part of the licensing agreement is that Toys R Us stores will act on your behalf here to protect your mark, to ensure that it retains its value and it sells a lot of products, and you then get a percentage of that revenue stream. Why isn't that sort of sufficient for attribution?
Well, we do nothing, Your Honor. We don't use the mark here.
You contract for other people to do something.
We make a contract in New Jersey and Delaware where Geoffrey does what it does. We do nothing here at all. Nothing.
Do you want to give up the money?
Beg your pardon?
Do you want to give up the money?
Mm-hmm.
You know, the money is paid to us in New Jersey and Delaware. A lot of people are not here who get money. Authors are not here, and yet they get royalties from their books. I don't see them here. We have athletes who get to have their name. You go to a sporting goods store, you see somebody's name on something. They get royalties. They're not here. We see people getting interest in...
Are you suggesting that, and I'm curious about this because I saw that in your brief, are you suggesting that those people, or presumably if they had corporations that they formed, would also be subject?
I don't think anybody should be subject, but I think
if in fact the appellate tax court is correct, authors would be taxed wherever their books are sold.
I imagine they should be. But I'm in court in Louisiana, and the state lawyer says, oh, we don't bother authors. Well, why not? I've had witnesses, experts, professors who say that they write books. I said, you report your royalties. Oh, no, we don't report ours. We're different. Why are they different? Why should we be singled out? Because it's a related company. They're an arm's-length company. This is a company with substance. The New York City Tribunal held that Geoffrey has substance. The department audited them and allowed some royalties from the other company which paid it to be deductible, so they know they have substance. But they're not here. The sign's not ours. We don't use it here. The stores use it here, and the stores pay their taxes. There is a whipsaw here if they go one way on fleet funding and another way on somebody else. And the big issue is there a difference between a sales and use tax and the other? But we say there's no difference. It's one Commerce Clause. You're either taxable or you're not. You do need a bright line. You need a bright line.
In your opinion, do we have to decide both these cases the same way, both Capital One Bank and your case?
Well, I would, but I think the Appellate Tax Board, for whatever reason, seemed to give significance that the state needed a statute for some reason to go after the banks. I don't know why they need a statute to go after them and not a statute to go after us, but they have a statute there. They seem to find an awful lot of activity, and I tried Capital One. they seem to find a lot of non-physical activity. Well, I don't think more non-physical activity versus less physical activity matters. But they seem to think it. They wrote it up that way. But neither has physical activity. Neither is here. There's nothing. And in our case, Your Honor, there's nothing here. Geoffrey has never done business here. It's never owned property here. It's never had employees or agents here. It's never had sales or payroll here. The agreement was executed outside the state. And with all of that, not only are they trying to tax us without physical presence, but they threw penalties at us. And I'd like to address the penalties if I could, please.
Before you do that, can I ask you one more question?
Certainly.
After the Sherwin-Williams case,
Yes.
the legislature passed a statute that basically discounted or wouldn't permit the deduction of licensing payments for marks between subsidiaries. I got it generally right?
Yes, Your Honor. I had the privilege of being before you
Yes.
for both Sherwin and Sims 7 years ago.
So how does the situation lie now? I know this is pre that statute, but would the state not permit the deduction to Trumi for the licensing fee, not permit that, and then also tax Geoffrey?
Absolutely right. This is right. You're right on the money. What happened there, Your Honors, here and many places, for at least 20 years, there has been a concern by states in general and here about relationships between affiliated companies. And different states go about it different ways, and this state, until we had the Sherwin-Williams-Sims oral argument 7 years ago, was disallowing the royalty deduction to an affiliate, period. They're just disallowing it. You wrote your opinions in 2002. You had you disallowed the deductions in Sims, you allowed the deductions in Sherwin-Williams, and then the state quickly passed a statute called an add-back statute. This is in 2003, saying no deductions for royalty payments and other payments to affiliates. So they ended the deductions in 2003. Then in 2008, just a few months ago, this state adopted the California system of combination, where they take affiliate companies that are in the same line of business, that are so-called unitary companies, and they just treat it all together for calculation purposes. So the problem is gone. This is not a recurring problem at all, and yet they're after us to tax us without physical presence. In the penalty area, there should be no penalty if there was reasonable cause for our position that we're not taxable. In the Wells Yacht South case by this court in 1990, you say that the ultimate question, whether there's reasonable cause, is one of law. And you say that to see if there's reasonable cause, you look at what the situation at the time of the taxable year. Let's look at the situation. Our years are the years ended 97 through January 01. What was the law at that point? The state points to a directive which said, trademark companies, you have to have nexus if you get royalty from the Commonwealth. Like I said, they didn't go after the authors. They didn't go after the athletes. They didn't go after other people. They just went after the foreign corporations. What is this directive? It's not a statute. It's not a regulation. It's nothing but their opinion. Well, I have an opinion, and many lawyers have opinions, that they're not taxable without physical presence because of what the law was at that time. Bellis Hess did rule in 1967, no physical presence, no nexus. 25 years later in Quill, they did rule that Bellis Hess was right. No physical presence, no nexus, and that's where they drew the line between due process and Commerce Clause.
Could you, and I don't know the answer to this, could you have asked? I mean, you said you have an opinion. I mean, could you have asked the commissioner for an opinion on whether Geoffrey was taxable under this or not?
They would have said yes, and we say
but-
no. You know, that's,
No, I understand that, and then you can pay it and challenge it. But I mean, there was a, you could
oh, I'm
have
sure
got-
there's a ruling procedure, but they would just say no. They'd say we're taxable. We'd say we're not, because why should we be? There have been 2 Supreme Court cases that said no taxation without physical presence, and they drew the line on the Commerce Clause distinction from due process, and they are different, Your Honor.
So your advice to your client most likely was take your chances because we don't want to get a ruling that says no, we'd rather wait and
As
take our
I read
chances.
the law,
And there is reasonable cause.
through
you believe.
01,
Yeah.
not only had Bellis Hess ruled what it did, and Quill ruled what it did. But the first state case after that, on March 1, 1993, at the Michigan Court of Appeals, the Guardian case held that there's one Commerce Clause, no taxation without physical presence of any kind. Along comes the summer of '93, when I first got involved with this wonderful company, Geoffrey v. South Carolina.
And you get this wonderful statement saying it's well settled that the taxpayer need not have a tangible physical presence in a state for income to be taxable here. It's well settled in 1993?
How could they say that?
Well, I don't
That
know.
opinion, Your Honor, is so wrong. And the great opinions in this field, in the last 15 years, there's been two great opinions. The Lanco, New Jersey Tax Court opinion by Judge Pizzuto analyzes all the cases, Commerce Clause, Due Process Clause, and the dissent, and I know dissents are dissents, but Justice Benjamin's dissent in MBNA is really powerful.
I take it they rule in your favor.
No, it's the reasoning.
The South Carolina Supreme Court, in footnote 5, blurs and muddles the distinction between due process and Commerce Clause. It says good enough for Due Process Clause, good enough for Commerce Clause. How can that be? How can that be? In footnote 1, they talk about nowhere income. This nowhere income concept is, well, if Delaware and New Jersey don't tax it, we might as well tax it. That's not how it works. It's Delaware income. It's Jersey income. It's up to them if they want to tax something. It's not up to South Carolina to say, well, they're not doing it. We're going to grab it. That's the only case that went the way, what I consider the wrong way, through our years. In 1995, Judge Thompson in Alabama said a great tax court judge, said, I respectfully dissent from Geoffrey. And he said, why? Now, they say, well, in dicta later, he backed off. But his two holdings in Chetro and Dial is no taxation without physical presence of any kind. That's 1995. In 1999, J.C. Penney National Bank, Tennessee Court of Appeals, said cert was denied at the U.S. Supreme Court on that one. J.C. Penney National Bank, there's one Commerce Clause, no taxation without physical presence. In the year 2000, Bandag v. Texas, and sure, the Court of Appeals in Texas said, well, registration's not enough, but they also said there's one Commerce Clause, no taxation without physical presence. So as we go into our end of our period, all these cases, except for the flawed South Carolina Supreme Court case, said under the Commerce Clause, no taxation of any kind without physical presence. And yet they pile on with the penalties. In the cases that they cite in later years, SYL versus Maryland, the tax court held it's a good faith issue. There should be no penalties. In A&F versus North Carolina, the trial judge held it's a good faith issue. There should be no penalties. Lanco versus New Jersey, good faith issue. They didn't even assert penalties. And yet we have these penalties which are piling on. It's unreasonable. It's wrong. We had a reasonable position. I think we're right, period, but even if we lose. On the merits, we get to the problem. The heart of the problem really is, do we need a national standard? I submit we do. Because if we don't, everyone is going to tax these intangible events. Everyone can say, well, let's take some TV program or something. They say, well, the TV is here, so the people see it. In New York, they'll say, they made it here. The actors might be in California. They'll say they made it there. They'll have multiple taxation on multiple taxation just piling up. We need the national standard. I think the courts that have looked deep into this have said physical presence is the right national standard. It's the workable national standard. Just for one Commerce Clause, the cases that went the right way, as I see it, I think looked into it. The cases that went the wrong way just sort of rubber stamped, well, good enough for Geoffrey, good enough for A&F, good enough for here, but they needed no real study. Thank you all very much.
Thank you, Mr. Solid. Mr. Barnico?
Thank you, Your Honor. My name is Thomas Barnico, Assistant Attorney General. I represent Commissioner of Revenue in this appeal by Geoffrey. As
Okay,
you've
let
heard-
me try a different way. How does the sales or use tax burden interstate commerce, but in a way that the income tax does not? What are the differences?
Well, the principal differences, I think, are mentioned in Quill and some of the state Supreme Court cases. They're 6,000 to 7,000 taxing jurisdictions in the sales or use area. The use tax is one collected not by the taxpayer, but by the vendor. There are difficulties presented to that vendor in keeping current on the use tax law of those 6,000 or 7,000 jurisdictions. There are issues that arise as to retroactive recovery when you look back and try to determine who the buyer was, to chase that buyer, so to speak, for amounts that were due in a later determination. As I said in my earlier argument, we think that determination of comparative burden is best looked at through the lens of stare decisis in quil, but that is the answer. In fact, one interesting, and making references to Congress just as Quill does, and an interesting part of the amicus brief for the Council on State Taxation is it quotes its testimony to Congress lately on bills that would establish the physical presence requirement not enacted. So it's a reminder of my point of the role of Congress in this entire area, that the amicus brief is citing its own testimony to Congress on the point. Now,
Where is this leading us? Are we going where Mr. Frankel says we're going, where every author whose books are sold in stores all over the country will then be subject to income tax?
Well, I don't think
in those states?
I don't think we're necessarily going there in Massachusetts, and that's black letter, Your Honor. There was a reference to the DOR directive of 1996, number 96-2. And as a matter of chronology, again, you know how I've emphasized that, Quill is 1992, South Carolina Supreme Court in Geoffrey is 1993, our legislature, in the midst of a reform of taxation of banks in 1995, passes the statute that's before you now. In 1996, Department of Revenue, realizing that the question of the trademark licensing and the intangibles is arising, sets out a very detailed statement on point. And one of the requirements for the imposition of the tax is the activity through which the corporation obtains such gross receipts, this would be the out-of-state Geoffrey, from its intangible property, that's the marks being used here in Mass, is purposeful. That is, a contract with an in-state company. So there is a category of these cases where property will be used somewhere in the United States where you wouldn't have fulfilled this requirement of purposefulness.
So if you're an author and Random House publishes your book, you don't have some purposeful connection to the sale of that book in Massachusetts. Is that what you're saying?
Well, I don't know if the department has a writing just on point, and I don't want to commit them here, but I think this is a useful citation in that respect. And it was
purposefulness is part of the substantial nexus test.
As regards the in-state ownership and use of intangible property.
Are you addressing here just the overall question or the punitive damages question?
It's actually both. You're right, Your Honor, because, of course, we say mostly that they were on notice in 96.
Yeah, but the problem, I mean, with the greatest respect for our sister court in South Carolina, I find it's a very short opinion. It has extraordinarily sweeping statements. And it's decided, and as far as I can tell, nobody has followed it since then.
Well, the DOR directive doesn't rely expressly on South Carolina.
I'm talking now on the punitive damages side. I mean, yes, it's Geoffrey. It so happens it's Geoffrey, but
I'm just making the point that unlike other cases that the court sees where there's an element of looking back, and arguments by the taxpayer are directed toward the fairness of that action by the taxing authority. Here, Department of Revenue couldn't have been earlier, so to speak, in identifying its position as to the trademarks, and then...
But I think that Mr. Solit is correct. That's its opinion.
Well,
I
we,
mean,
s-
if you hold a, I'm talking penalties
Right,
now. If you hold a strongly differing view as the taxpayer, it's not just, you proceed at your risk, but you, I mean, it strikes me that at least for the taxable years, there's not an awful lot of, that's the department's position, and that's okay. It's a,
well, I think reasonable cause goes to the situations where there was no guidance at all. And so in that instance, when we have to chase them, they would have, may have
But
reasonable
why
cause.
is there no reasonable cause when they have Supreme Court decisions that are very arguably in their favor?
that's my point.
Well,
I mean,
there wasn't,
Justice Cowan is just articulating it somewhat differently.
they had nothing on trademarks in a corporate income context. That's
No,
why
but
they
they-
lost in South Carolina.
But they could rely on the cases they could rely on the language in Quill and in Bellis Hess and
Well, they could rely on it, but they did.
I mean, it's
as a
not
matter of that-
unreasonable to rely on it.
Well, the commissioner and the board felt otherwise because, as I said, primarily because in Massachusetts, the rule had been set out. They nonetheless ignored it, and they proceeded at their peril. So they're different than a taxpayer who was faced with ambiguity from the Commissioner of Revenue and proceeded on that basis.
You're saying because it's the Commissioner of Revenue and that's an opinion, it stands in a different position than Matthew, taxpayer on the street, and that maybe it wouldn't be fair to impose penalties if the Commissioner's opinion was so off the wall that it was impossible to follow. But if it has an arguable basis, it trumps an arguable basis on the other side. Is that what you're saying?
Yes, and when you read this, you'll see that it's almost jot for jot directed to exactly the kind of arrangements that Geoffrey had. So if this is all about notice and reasonable cause as to what our position to be, we can assess penalties without having to show that we were 100% right or that we'd necessarily win the case. It just has to do more with notice. So the purposeful aspect is demonstrated here on this record, which I think is a worse record from Geoffrey than it had in some of these other cases. Oh, go ahead.
But purposeful, are you saying that purposeful is part of substantial nexus, that the activity, the economic activity that you say is in this state, in other words, the mark is being marketed here, has to be purposeful by the owner of the mark? Is that part of substantial nexus or not?
By the terms of the DOR directive, yes.
But the Commerce Clause wouldn't require that, or would?
The Commerce Clause, it would be an element of their connection. It could be proof of the nature and extent of their connection.
Okay. So your argument here has nothing to do with the fact that these are affiliated entities. They could be completely unaffiliated, as long as it was the use in Massachusetts was purposeful by the owner
Well,
of the
actually,
mark.
it's one and the same because the affiliation between the companies tends to show that they knew that the mark was going to be used in Massachusetts.
I copyright. I'm an athlete. I copyright my name and a photo and this and that, and I sell it, license it to a sporting goods chain. They have stores all over the country.
Maybe it's useful then to return to the statute, because here, of course, we're not involved with a financial institutions excise, but the general corporate excise tax applied to foreign corporations. And on the terms of that statute, they are doing business here.
I've never been to Massachusetts. I just licensed my name and my picture to a national sporting goods store, which does business all kinds of places and sells stuff with my mark on it.
Well, their property is being used in Massachusetts.
My property.
Right.
So I'm in Massachusetts, never left the state, sold it to a company here, and they.
But you see there, that's and probably why DOR limited it to this purposeful aspect is because then you're bumping in even to the due process notion that if you had no, if there's no evidence that you or could be assigned any responsibility for the property ending up in the state, then
Why are you resisting having purposeful be part of what a substantial nexus is?
Because our statute is very broad as to the definition of doing business in Massachusetts includes the use of one's property in the state. I think it is an element in the vast majority of these cases where taxes will be imposed. You'll be showing that, just like in this court's case in truck renting, while that was physical property, it wasn't just that the tax, I agree, it was present. It wasn't just that the trucks happened to be used by the lessees here, but that the lessor, out of state, on the record, showed that it had taken steps to facilitate that use here. So too, these companies.
And isn't there a contractual relationship between Geoffrey and Truly?
Not only that, the latter's a Massachusetts company, and that contractual relationship governing the use of the marks specifically intends that they be used in the 24 stores in Massachusetts. Right. So in that case, the case before you on the trademarks is stronger than Geoffrey, South Carolina, and stronger than some of the other Geoffrey cases, because that contractual agreement actually has to do specifically with Massachusetts, and the same contract says that the calculation of the payments from Mass to out of state will be calculated in part based on Massachusetts sales. So the connections, the nexus, so to speak, to Massachusetts are all over these documents. And I know there's a litany that they're not here for this reason, they're not here for this reason, but they sure intended to be here, at least in the respects I just mentioned.
With respect to this sort of substantial nexus analysis, does this also encompass, and this may be another one of the factors, that the notion that the tax should be fairly related to the services provided by the state? Or is that a different concept? Is that, I mean, what services are being provided to Geoffrey by the state of Massachusetts, for example, for which tax should be fairly related?
Those are generally described as the sort of police power protections that allow the marks to be used and, to enhance the sales, which in turn become a measure for the royalties. Sometimes in these cases, that protection is described in terms of the opportunity to go to court to protect your mark.
And you would argue you
business.
don't need to have shown that it isn't necessary for the state to show that this taxpayer has used the courts. It's just the potential is there for it to use the court.
In Geoffrey, it's the potential, the record. So, and there are cases that say it's the potential. In Capital One, it happens to be the fact that they came here, obtained judgments, and obtained writs of execution in a small number of cases, but that protection was actually utilized in this case.
Of course, they argue that because there's no physical presence here, they don't use the police and the fire and the sanitation and the highway services the way other taxpayers
Right, that
do.
the taxable corporation isn't here physically to obtain those benefits. The other side of that argument is yet the beneficial or the productive use of their intangible property is enhanced by all those protections. Their licensees get to use those marks successfully because of the protections we afford. It does happen to be another prong of the complete auto, though it fits into that other prong not contested here about whether the tax bears a fair relation to what the state provides. But what the state provides is often described in those pretty broad terms. Of course, Geoffrey's distinguishable from the Capital One just in the sense of the quantum of cases. There are more you probably already realize there are more cases on trademark, many involving Geoffrey, than there are on the bank credit card area.
Your time is up.
If there are no further questions, we ask that the board's decision in Geoffrey be affirmed. Thank you very much for your attention.
Thank you, Mr. Veronica. you.
Oops, that's okay.
Good morning, Mr. I'm so sorry. Take your time, Mr. Barnacle.